Hello, my dear friends. I am Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. So, in today's lecture, we will cover a very important topic of law of tort, that is essentials of tort. We will cover all the essential of tort in this particular lecture. So, let's start the topic. Tort and its essential we will discuss in this particular lecture. So we have discussed in the previous lecture introduction of tort, meaning of tort, definition and objects of tort. If you have not watched that particular lecture, please go to my channel, select the playlist of law of tort in English where you will find the first lecture. Please watch that lecture and after that you try to watch this particular lecture. So in this lecture we will discuss essentials of tort. So when a person commits a tort, thereby another person suffers damage or injury, the injured party can resort to a remedy by instituting a civil action. So whenever a person commits a tort and due to the commission of tort, if any person's legal right is violated, then he will be entitled, the injured party will be entitled to file a suit before the court of law, before the civil court of law, and he will be entitled to get a remedy, compensation. So whenever any person's legal right is violated, he will be entitled to file a suit in a civil court and can claim a compensation. Injured party is called plaintiff. So the persons whose legal right is violated, the person who sustained a injury, who sustained a loss will be called a plaintiff, and wrongdoer is called defendant. The person who has violated the legal right of plaintiff will be called a defendant. The wrongdoer is called defendant. The person who has committed a tort is called a defendant. Then the plaintiff, to be successful in his action against the defendant, has to prove the following condition. Suppose if the plaintiff wants to win his case, he has to prove a certain condition. After proving such a condition only, he will succeed in his claim, he will get compensation, otherwise not. So what are those conditions? What are those essential? We will discuss one by one. The first and very most important essential of law of tort is wrongful act. So to constitute tort, there must be a wrongful act committed by the defendant. So whenever we want to constitute a liability of defendant under a tort, so we have to prove that the act of the defendant is a wrongful act. Without proving the wrongful act of the defendant, we will not be entitled to get any kind of compensation under a tort. So the very first and foremost essential of tort is wrongful act. The defendant act must be a wrongful one. Wrongful act denotes the commission of an act as well as omission to do an act. So the wrongful act is a commission as well as omission to do a certain act. Suppose if I throw a stone on the car of any person due to which the person sustained a loss, my act will be a commission of act and he will be entitled to file a suit against me and my act will come under the category of wrongful act. As well as suppose if it is my duty to do a certain act but I fails to do that act, it calls omission to do an act. So both will comes under the category of wrongful act. Wrongful act or omission must be recognized by the law. So that particular wrongful act or omission must be recognized by the law. If there is a moral or religious wrong, the liability will not occur. So whenever plaintiff wants to get a compensation under a law of tort, the act of the defendant must be a wrongful act. And that wrongful act must be recognized by the law. If the act which is committed by the defendant is a moral wrong, there will be no liability of the defendant. If the act of the defendant is a religious wrong, there will be no liability of the defendant. What is the base to constitute the liability of the defendant? That is a wrongful act which is recognized by the law. Suppose to feed a person who is suffering from starvation, that is a moral duty. Suppose if any person who is suffering from starvation, it is my moral duty to feed that person. But suppose if I fails to feed that person who is suffering from starvation, my act will be a moral wrong. I will not be held liable under a tort. To constitute the liability under a tort, my act must be wrongful act which is recognized by the law. So if there is a religious wrong, if there is a moral wrong, I will not be held responsible for that. What is necessary? Wrongful act must be there. If the act is done under some lawful excuse, is not the breach of duty. Suppose if the defendant is acting under a certain kind of lawful excuse, there will be no liability of defendant. Suppose if the police officer is chasing the criminal, and while chasing the criminal, he enters into the premises of any other person without his permission. So we knows very well, if any person enters into the premises of another person without his permission, it will be a trespass. But police officer is doing his lawful duty, and while doing his lawful duty, while he was chasing the criminal, he enters into the premises. So that is a lawful excuse. Police officer will not be held liable. The act of the police officer will not be a wrongful act. So to constitute the liability under a tort, the act of the defendant must be a wrongful act. There are a certain example of wrongful act. This is the erection of wall is the first example of wrongful act. Suppose if any person, if the defendant erected a wall in the way of plaintiff, the plaintiff is using a particular way, and in that particular way, in that particular route, if the defendant erected a wall due to which plaintiff could not use that particular route, the act of the defendant will be a wrongful act. Plaintiff is entitled to file a suit against the defendant and can claim a compensation because the act of the defendant is a wrongful one. Next example is keep the dog escape. Suppose if I am having a pet dog, it is my responsibility to tide that dog. It is my responsibility to take care of that particular dog. If I kept that dog escape, and if that particular dog has caused any kind of injury to any person, then I will be held responsible because my act will come under the category of wrongful act. So if I am having a pet dog, it is my responsibility to take care of that particular dog. So keep the dog escape is an example of wrongful act. Next one is trespass. So we know very well, if we want to enter into the premises of any person, we cannot enter without obtaining his permission. But suppose if we enter without obtaining his permission, our act will be a wrongful act and we will be held responsible for the trespass. So you can see in these two images, this is the example of wrongful act. Another example is that defamatory statement. In this particular image, XYZ Galleries director is a thief. This is a defamatory statement. If I passed a defamatory statement, if I publish a defamatory statement against any person, my act will be the wrongful act, and against whom the statement is published, he will be entitled to file a suit against me and he can claim compensation because my act will come under the category of wrongful act. Another example is that drive car in excessive speed. Suppose if any person is driving a car in excessive speed, his act will be a wrongful act and he will be held responsible for tort. So the first essential to constitute the liability of defendant under a tort is a wrongful act. Second essential is legal damage. So not only the wrongful act is sufficient to constitute the liability of defendant. If by the wrongful act of the defendant, if legal damage caused to the plaintiff, if plaintiff's legal right is violated by the wrongful act of defendant, then only defendant will be liable to pay a compensation to the plaintiff, otherwise not. So to constitute tort, there must exist injuria, which means infringement or violation of legal right. So legal damage means violation of legal right, infringement of legal right. So until and unless the legal right of plaintiff is violated due to the wrongful act of the defendant, defendant will not be held responsible. So suppose if plaintiff wants to get a compensation under a tort, he must prove the act of the defendant is a wrongful one, and due to the wrongful act of defendant, I have sustained a legal damage. My legal right is violated. If he proves these two things, he will get compensation, otherwise not. If the act of the plaintiff, if the act of the defendant is a wrongful one, but there is no violation of right, defendant will not be held responsible under a tort. So, by the wrongful act of the defendant, if plaintiff's legal right is violated, then only he will be held responsible, otherwise not. The real significance of legal damage is illustrated by two maxims, namely injuria sine damnum and damnum sine injuria. So this particular concept, legal damage, is illustrated by two maxims, injuria sine damnum. The very meaning of injuria sine damnum is violation of legal right without loss. If person's legal right is violated and without loss, he has sustained no loss, but if his legal rights is violated, he will get a compensation, because the violation of legal right is a very much essential to get a compensation. If a person's legal right is violated, though he has suffered no loss, he will get compensation. And the second maxim is that damnum sine injuria, matlab loss without violation of legal right. No doubt the person sustained a loss, but if there is no violation of his legal right, he will not get a single rupee as a compensation. So to get a compensation, person's legal right must be there. So injuria sine damnum and damnum sine injuria we will discuss in separate in next lecture in detail. So second essential of tort is legal damage. Third one is legal remedy. The law of tort is said to be a development of the maxim ubi jus ibi remedium. Meaning of this maxim is where there is a right, there is a remedy. So if the right of the person is there, if that particular right is violated, definitely there will be a remedy for that particular person. Where there is a right, there is a remedy. The meaning of ubi jus ibi remedium is where there is a right, there is a remedy. If a person's legal right is violated, no doubt he will get a compensation. So the three essential of tort are there. The first essential is wrongful act. Second one is legal damage, means violation of legal right. Third one is legal remedy. Where there is a right, there is a remedy. So these are the three essential which plaintiff has to prove if he wants to get a compensation under a tort. I hope you understand the essentials of tort. If you understand, please subscribe my channel, hit the notification button, hit the like button, and share this video with your friends. Thank you very much.